Good morning. My name is Adil Patel. I'm from Cliff Decker Hofmeyer, and with me are my colleagues, Fiona Lipan and Professor Hugo Pienaar. On 9 February 2023, the head of the National Disaster Management Center classified the impact of the severe electricity constraint in South Africa as a national disaster in terms of the Disaster Management Act. On the same date, the Minister of Cooperative and Traditional Affairs, the then Dr. Zuma, declared a national state of disaster due to the impact of severe electricity supply constraints, with a statement in the regulations that other ministers may issue further regulations. We invite our clients and potential clients to this speed dating webinar because, unfortunately, unlike COVID, we don't have the answers. So, like any speed dating, this is a high impact, thought-provoking webinar where we pose more questions than answers. But you may ask, why is this beneficial to you? Because unlike COVID, we were all shooting from the hip and developing the law as the regulations were enacted. In this case, we have time to prepare, but it may not seem so given the fact that we have large amounts of load shedding, traffic lights don't work, and that's the reason we didn't invite you to our offices, because we were really concerned that you may get caught up. So before I start the discussion, there are two case studies that you should know about. The one is in Brazil and the one is in Argentina, where they had large amounts or long periods of load shedding from 16 to 18 hours. And what had happened there is similar to COVID. Government had created a fund. Government created a fund where it remunerated employees who are unable to work. So similar to COVID, it's unlikely that we're going to have that situation. In South Africa, we simply don't have the funds for it. Now, before I hand over to Hugo to give his introductory remarks, as well as Fiona, let me put the following to you as business leaders. Most businesses are dealing with business continuity program from an IT perspective, production, and the like. Based on our information, very few are looking at the employment component, and most organizations, their biggest costs are rental and employees. And if you're not looking at them, if you're not looking at the employee numbers or the employee impact, then you pose a real risk. So before we start the discussion, let me give Hugo and Fiona some opportunity to make some introductory remarks. Fiona?
Thank you very much, Adil. I think that we are approaching a matter of this nature against some difficulties with regard to how our Labour Relations Act is constructed and the case law underpinning it, to determine what are some of the options that employers may have. And this is why the declaration of the state of emergency, I believe, came into existence, was because where there are gaps in that legislation, we can see them filled in by way of directives, etc., issued by the various cabinet ministers under the portfolio of the Cogta minister. And we need to be I think, quite perceptive as to what those gaps are, how we might fill them, because we don't want to wait until we're told what to do. We need to start thinking very seriously about how we can manage this problem going forward. We're heading for winter. Our grid is under enormous strain. And although there are attempts to repair power stations such as Tutuka, which has suffered particular difficulties, and that, if it's resolved, will add more weight to the grid, that's not a given, because unfortunately we've got an aging infrastructure and that's going to create its own difficulties. We've got water shortages coming on board. We shouldn't be looking to ignore that. And so I'm saying start getting proactive. And therefore, what can we do as employers to try and make sure we can stay in business?
Thank you, Fiona. Hugo, some introductory remarks before we start posing some thought-provoking questions to you.
Thank you. Yes, I agree fully with Fiona, but of course, I must just say that I'm grateful this morning for two things. One is that it seems that our lost cricket boys have returned, and secondly, I'm so grateful that we don't have to discuss compulsory vaccination again this morning, especially given Brazil that has now said that you can potentially be imprisoned for that. But the point being, and I agree 100% with Fiona, it is up to employers to be proactive now, to think out of the box, to consider that we will discuss a bit later, options that I think are not available, but opening other options within the framework of the Constitution or otherwise. And I think that's where we need to be as employers, is to start invoking these thought-provoking discussions.
Thanks. So let's start off with some basic questions. At an individual labor law perspective. So an employee has a starting time to attend work. 8 o'clock in the morning or 6 o'clock, whichever their shift starts, or they need to be at work, and they leave promptly from home and they're unable to attend because either there's a gridlock or traffic lights are not working and they're half an hour to 45 minutes late. And this is a consistent thing over a week, and you warn them the first, and you give them an oral warning, and you give them a written warning. And in those circumstances, whether you justify what action is available to an employee currently as well, we're in a state of disaster at the moment, and we're having employees not able to come to work on time because there's just load shedding everywhere in this country. I hope I haven't stunned anyone, so you go, let's go.
Right, so the first point of departure is the normal no work, no pay principle will apply, because we have the scenario where the one party is not able to tender its services. And ordinarily, if we go back to the COVID scenario, when we had the regulations, total shutdown, then the scenario was quite simple. Neither the employer nor the employee was in the position to render services or to take up employment. And hence it's quite simple, no work, no pay, force majeure applied in its totality. I think what we have this time around is not a total shutdown and regulations that allows for that argument. But of course, what we want to discuss a bit later is potentially the development of that area. In terms of discipline, I think that I would be cautious to dismiss employees under those circumstances. But that's really just a short of it. I think we can look at the other options later, or the options that's not available. Those are the more important stuff.
Yes. So Fiona, an employer is unable to work or run its operations. What options are available to it from a legal perspective? We all may have moral obligations in relation to paying employees. So can an employer say, you know what, I can't operate permanently, so I'm not paying you.
So that does take us back into the debate about the impossibility of performance, because if the employer is unable to operate, and if employees are unable to tender their services where that's a reciprocal element, then you have the supervening impossibility of performance. If that had to be a temporary situation, contracts could be suspended in that time. If it were to be permanent, under our common law, we know that that would have led to the contract of employment becoming void. But of course, where we have to be careful in the employment law setting is we have the overlay of the Constitution, the Labour Relations Act, and we can't terminate employment without taking care of the procedural angle as well as the substantive reason for any termination. If it leads to retrenchment, we've got obligations in that regard before we can seek to terminate employment. But the big question is whether it's a reciprocal inability to perform. If an employee is unable to attend work because they run, or rather they run late, as your first question posed, then that's a slightly different situation for me, because I'd want to know, is that a general problem that my employees are facing, or is this some stragglers who could do better by simply coming to work or trying to get to work at an earlier point to avoid these difficulties where their presence at the workplace is absolutely compulsory. It's not work that can be done remotely, because if it's a straggler, then my viewpoint would be it's discipline. If it isn't, and it's a more generalized problem, well, then I'd want to have discussions about how do we look to ameliorate this? Do we change production hours? Do we try and start later, earlier? How does it work? Can we have some level of certainty, of course, with regard to load shedding stages? That might be one of the reasons we need to approach the relevant government departments under this declaration of a state of disaster, because we might want to be exempt from certain periods when load shedding would be applicable to us, and we need to see whether that's an option, because certainly I saw that Adil, in the articles you circulated with regard to the problems in Argentina.
Good. So Hugo, are we allowed to place employees on annual leave as opposed to simply saying to them, we are not going to pay you, yes, we're not going to pay you because you're unable to tender services, like we did under COVID, where we placed employees on annual leave, statutory annual leave?
Well, I think that is part of the long-term plan that employers should have as an alternative, because one morning you will arrive and all of a sudden there's a total shutdown of electricity. It will be for an unpredicted period. You don't know whether it's going to last for a week or 2 weeks. And ideally speaking, you want plans in place before that happens. And my sense is what employers should already do at this stage is to start consulting with its employees and its workforce and unions to find a sort of a framework of a plan. And what you want to do in terms of that would be to address it under the heading of job security and safety, which I think Fiona can also talk about in more detail, but use that as a basis to get into a framework agreement where you address exactly those concerns. Let's use leave, let's use short time, let's look at alternatives, let's look at temporary layoffs and the like. But of course, ultimately, looking at job security and maybe even provide not only to payment for leave and the like, but also for unpaid periods of leave and suspension potentially of employment. So those would be options that employers may consider, but have an absolute open and transparent discussion. You may even have to disclose information subject to the provisions of Section 16 and protecting your rights in that regard. You may think of some sort of incentive. And if you have a framework agreement, even do a Section 23 agreement, if possible, when you deal with majority trade unions to extend that. But part of that would be to address the issue of leave, Adil.
But that's quite an important point and takes me to Fiona, because what you're suggesting is a solution. So we know we're going to have a problem. We know we're going to have absenteeism. We know we're going to have low production. We know our economy is going to take an impact. We know that our profit margins are going to go down. The increase in discipline, remote working is going to be an issue. So you've set out a proposal. You've said, we've come to you now to start planning for when it's going to come. So Fiona, What others, so you guys told us about short-time layoffs, leave. Are there any other things that we could consider? What about retrenchments and industrial action during a period of, during this national state of disaster in that framework agreement, if your thoughts on that?
Yes. So I think that what one can do in certainly planning to have in place such an agreement, you want a dispute resolution mechanism built into that. And you'd like to try and avoid industrial action as far as possible. So you might look at alternatives to industrial action, which might speak to facilitation, mediation, and the like, to try and break any deadlock. Should we have that type of problem in trying to put together a plan? Because I like the idea of the plan, because you're looking at options which keep the employment relationship intact. It's just a question of payment, because what you don't want to have is the situation where the employer cannot operate, but employees are there to tender. And for as long as that is so, and they could otherwise tender, they say, well, then we're entitled to be paid. That's an enormous drain on the employer and impacts the mothership and its viability. So the dispute resolution mechanisms that would be born out of a collective agreement in those circumstances would be critical. And one can be very creative in that regard, I believe. But also, I think if we've got a good relationship on the ground with employees and with trade unions, we should be able to start talking about payment and what's affordable. But here, employers have already got themselves into difficulty in one matter that has been reported recently involving Southern Sun Hotel Interests and Sakau, where there was an existing collective agreement dealing with wages and other conditions of employment. And because of the COVID pandemic, the employer said, I can't afford the 5.5% increase. I know I'm supposed to pay it under that rubric of the collective agreement, but I'm now going to put a demand on the table that you agree to drop that demand. The employer got into difficulty. And when it tried to lock out, when it couldn't get agreement with the union on that reduction, you had the Labour Court interdicting the lockout and declaring it unprotected, because the Labour Court and Labour Appeal Court sounded a warning to employers. Be careful. You've got a binding collective agreement in place. You can't just put in a demand with a view to taking away the gains that employees have managed to secure for the purposes of that collective agreement. So you've got to start looking, when you're doing this planning exercise, at what are the collective agreements you have in place, underpinning what the options might be that you arrive at. And if there are issues with regard to affordability on a collective agreement with wages, etc., you've got to find way more and better creative ways of managing that. And you've got to be able to take your employees with you, because at the end of the day, you want to avoid retrenchments if you can. You want job security, because job security is not just about earning the wage. It's about the benefit schemes to which contributions are made for pension, for medical aid and the like. We saw in the Nahawu strike, what was one of the major demands there? We want more money put into medical aid so we can have better health facilities and access to healthcare. An irony, because it was the healthcare workers on strike, when in instances they shouldn't have been, where they're essential service. But what it does tell you, the narrative's changing. So you've got to be up to speed with that. Thank you.
Just before I take Hugo, because I want his thoughts on just what you've indicated. At the moment, if you're concluding any collective agreements, based on what Fiona has said, we're in a state of disaster. You must have a get out of jail free card within that collective agreement to allow you the opportunity to renegotiate that, where as a result of the state of disaster, you are severely impacted, or your operations are severely impacted from an economic perspective. Hugo, what are we doing about strikes in this framework agreement and during the state of disaster?
Well, I think it's useful to look at that morning that you arrive at work and you have the scenario and there's no work, no electricity, unforeseen time period that we're not going to have that. What are we going to do? And what are our options? But more in particular, what options are close to us? And the one is that can we invoke the provisions of a lockout or maybe of a shutdown, because that's an alternative. But again, when we look at the options available, certain time periods either make it impossible or unfeasible to implement. One is, for instance, a normal lockout, because now you have to refer the matter to the CCMA bargaining council. You have to wait to 30 days notice, etc., and then you give notice of a lockout. You will, depending on your financial circumstances, potentially not have that. You may not have the option to say, I'm now going to invoke a retrenchment, because that may take you 30 days or 90 days if it's a 60-day consultation, 30 days notice. So again, that's not possible. The point Fiona made is that we can't just unilaterally impose different conditions of employment because you may be hit in terms of the Max Steel judgment. You may not, for instance, apply, or you may apply for exemption, but again, that's too late. And hence the point is we need to be proactive. And so yes, collective labor law and all of its consequences may come into play, but you may not then have the luxury of time for it. If you do, of course, you can invoke a lockout provision, subject to what Fiona said in terms of the Southern Sun judgment.
So let's just look. Sorry, Hugo, please go.
No, sorry, I was just interested. I think there's another option, but that's probably a more brave one. And this is where employers to say, well, currently, I think, Fiona, you alluded to the UK case law of the doctrine of frustration, which really deals with the principles of force majeure. And in terms of the UK case law, harsh economic hardship constitutes a way out. In our law, we're not there. The case law is clear, but we know that one, in terms of the Constitution, section 39(2), it says when you consider the common law, you must develop it. The courts are empowered, in fact, instructed to develop that principle of common law to comply with the spirit of the Constitution. Also, the court our labor court is a court of law and equity. So it opens it up to the brave employer to say, let me explore this and try and use force majeure as a defense. But you must be able to take and have the money and otherwise to take that matter to the Constitutional Court. But it would be quite an interesting debate in the long term, because force majeure would if we follow the UK law, would constitute a defense. In terms of our current law, it doesn't.
The interesting legal question that's going to emanate is whether the normal legal principles or the normal time periods apply during a state of disaster. So we know that the LRA says that it takes precedence over any other law insofar it doesn't conflict with it. And whether this, under a state of disaster, you could potentially argue, based on what you said, the time periods must be abridged as such. I think that's going to be a long ask, but I think it's something worth. But I think all of those are reactive. The solutions, that solution of doctrine of frustration, vis major, placing people on leave, is a reactive. What we're proposing to colleagues is a proactive stance, and that is why we're having this particular session now, so to allow you to start preparing and to start at least thinking about what's doable for you. Now, let's go to where we are. So now we start, we have a proactive employer, starts engaging, says there's a state of disaster. We are potentially, the grid may collapse, or we may have large bouts of no water because of electricity shortages and the like. And there's the current case of Eskom and government and the UDM and the political parties going to say exempt certain entities. The employees say, we refuse to be proactive. We refuse short time. We refuse to take a salary cut. We refuse to agree to retrenchments. So we're sitting now on the 30th of March, on the 29th of March, 2023. The grid has not collapsed. We don't have large bouts of electricity shutdowns, load shedding. at the moment, because it seems that we potentially may be burning quite a bit of diesel at the moment. Whatever that narrative is, why we into level 1 or level 2 load shedding. What are our options to the proactive employer, where the employee says, I refuse to change terms and conditions because the situation has not yet presented itself, and don't talk to me now?
That is such an interesting one. Sorry, Fiona, do you want to go with safety, or shall I?
But can you see how they salivate because of these legal discussions, right? So let's go.
Yeah, and I think we need to be proactive when we do this. And my sense is, if they do not want to cooperate, obviously we know we can't commence with the retrenchment because we can't contemplate, you can't really do a 189.3, but the Act says that you must consider alternate. When you do a retrenchment, you must tell the union what alternatives you've considered and why it hasn't worked. I'm talking about the consulting party. So that would be a point. So I would almost by way of instruction say that we have safety considerations, and I think that's a point that's important, and Fiona can talk about. We have job security that we need to address. We're now moving into a state where we're going to say, and that's just thinking of the cuff, we instruct you to participate in this process. We need to, and if people do not want to, maybe one must consider adopting a policy and say, this is probably brave, but here's a policy, that is what I'm going to do, and this policy, I throw that out to consultation, so that if that morning arrives, you at least have some sort of fallback. And I've not been thinking through this probably in sufficient detail, but I think the point you've made, we need to be proactive and we need to be brave. That's maybe an option. And as I've stated, not only use the job security, but also the safety argument, that it's in the interest of safety. It's an operational requirement in terms of safety that we need to address a scenario where people, if they tend to work, it won't be safe for them to work, whether it's because of night work, mining, and all of those.
Fiona, your thoughts?
Okay, so I would like a framework agreement to possibly include some of these aspects, because a union might well say, look, if we have a complete shutdown on the grid, well, then that tells us where we're at. We can't tender our services, our members certainly cannot, the employer cannot operate. We understand it's no work, no pay. But that's cold comfort, because along the way, businesses are suffering financially. And what you want is employees to be a lot more flexible with regard to their conditions of employment in terms of layoff and short time, etc., or even a reduction in pay. And you will get some employees who will say a flat no to any changes in terms of their earning capacity. Now, that's an option in the framework agreement to allow a process where those persons are exited and they leave. They might not get severance pay. That's going to be an interesting debate under Section 41 of the Basic Conditions of Employment Act, because I've got an alternative to get past this particular difficulties that we are facing with load shedding. So if you were to be retrenched, well, you may not get your severance pay, because that's a lever to draw the person into your midst and to be reasonable. But I think, again, obviously trade unions can be strident, but you often get voices of reason within those organizations. You want to at least harness that with a view to saying, all right, if this happens, this is how we wish to approach it. Short time layoffs, etc. Those persons who are not interested in that, at that point, within the framework agreement, you have a retrenchment process which can truncate those time periods otherwise applicable in the Act, because we've agreed it with the unions, and we allow an exit of those persons. Severance pay, a different debate. We'll have to look at that carefully.
Let me just pause before we get on to the next part in the last 15 minutes, the regulatory part. This, and you mentioned it, right? That we cannot commence retrenchment now because we haven't contemplated retrenchment. But this is the scenario. And a TED talk once said that you must, as an adult, you don't start with once upon a time, but you should start with a story. So you have February 2023 declaration of the state of disaster to say that we have a problem. So the identification of the problem is there already. You have a second set of regulations issued, which then says that the minister, various other ministers may issue other regulations. The question that I have is the legal question. If a brave employer wants to commence Section 189 periods now, but then say that the termination date will be when an event materializes, either when there's a shutdown or when our profitability lasts. So I'm asking two questions. Is there an argument to be made that we are able to utilize the state of disaster as the basis for our 189 notice, and then whether we can change termination dates? And then if people don't agree within the framework, we put all of those options within the 189 consultation now. I know it's a mouthful, but it's a scenario planning as an alternative where employees are being strident in relation to the framework agreement, the proactive. And then you say, well, if you don't want to do that, here's a 189 and whether that's possible. I think our hurdle is the contemplation. Fiona?
So why can't I build that into the framework agreement? I build in my whole retrenchment process as if I had to go through that.
Yeah.
So that the options are there. I'm going short time. So you're going to work, for example, 3 days a week because we're only going to get electricity on 3 days, for argument's sake. You work those and you don't get paid for the rest. And as you build this into such a document, if you've got persons along the way that are saying an absolute flat no, then what you want to have included is their exit. Now, you can do these things by agreement because that's, after all, contemplated within Section 189(3), because the employer, before it gets anywhere close to forced retrenchments, can actually lay out what are the alternatives that it has put up and why those were rejected, what were the reasons for the rejection or the reason why they weren't palatable to workers, and take it to the next step. So you've actually done a lot of the consultation before you would ever get near a forced retrenchment, if in fact it's necessary to have a forced retrenchment. Because my argument is build that whole forced retrenchment angle into your framework agreement, if you can. It might be a big ask, but you might get traction on that, and it's worth trying. Because all these steps that the employer takes along the way, if you eventually have to do a forced retrenchment, is you've shown your reasonableness. And that's where you want to buy, if you like, that's probably the wrong term, but you want to garner the support for your strategy to be able to say to a judge down the line, if you're put to the test, say, well, what else could I do? I, as the employer, have taken these reasonable steps. I didn't get traction. If there's a loss of a job, so be it, because then I'm free to go out and employ persons that can work on the terms and conditions that I want. What I mustn't confuse is the collective bargaining component versus the retrenchment angle. We know that from the Avenge case with NIMSA that went all the way to the Constitutional Court. I must always have a proper bona fide economic rationale for what it is I'm doing if I go the forced retrenchment route. It's not because of a failed negotiation process. So there is a tension there that has to be very carefully managed.
Yes.
Here you go. So let me just put the question, what would be the situation if the employees refuse to accept or refuse to sign this long-term agreement? What are our options then?
Yeah.
To be as a proactive employer?
Well, as I've indicated earlier, I think one of the starting points is if you have an existing policy, you can maybe explore on that. Secondly, if they close all avenues, maybe the option is to then invoke the 189.3. And what you would ordinarily do, and it's not unheard of to have a phased in or an intermittent sort of retrenchment. I commenced my consultations in January. I'll close down this factory or this part in May and this one in July, and I'll simply implement it on those days, the agreed agreement. So you then invoke the 189.3 almost as an anticipation. And I know what we've said about the cautionary notes about that. But what we're doing essentially now, we're already drafting all those annexes to court papers. And the way you document it, I think it's important, the point that's been made before is that please just don't go into a negotiating mode of wanting to change conditions of employment. And if it doesn't work, then you fall back on a retrenchment. That I think as Fiona has explained, is closed that door. But I think if there's an existing policy, that's a starting point. But you have to be brave and then simply say, I'm going to invoke this process because of sub B, i.e. these are the alternatives, and I want to start with that and take it with safety. I think job security and safety is key, because that's where you'll create sympathy from the court. You want to act in the interest of the employees, and you want to create long-term security. That is the focus and the sympathy that you want.
Tony van Niekerk has posed a question which leads us to the end of our presentation or the speed dating, and I hope we found many dates to go on, or many companions to walk this journey with. What is potentially, and Tony mentions this, that the regulations which may be issued by various ministers would potentially prohibit retrenchments and would potentially prohibit any sort of industrial action. So let me just say, firstly, on the issue of industrial action, we have a constitutional right to strike. We have the LRA, which takes supreme. So it will be a brave government that will do industrial action. But just we have to pontificate as to what would be the consequences on whether government would be able, insofar as it sought to restrict retrenchments like it did to prohibit evictions, whether an employer organization would potentially be able to set aside. I know there will be litigation, but be able to set aside those regulations. It's an admin law issue. But interplayed with some employment law issues. You go, Fiona?
Yes.
I think.
Well, shall I just go quick? I'll be
Go
quick,
ahead,
and then
sure,
you can do
go
the
ahead,
proper
yeah.
closing, because you're much better at that than I am. So I think that any minister who's prepared to do that must also be brave. Because if the minister stops me from retrenching or from operating or exercising my normal economical rights, which are also enshrined in the Constitution, then the minister must give me the money to pay my employees, because I can't afford to pay them. I think it will be almost an impractical solution unless there's money to be paid. And we know that we've just increased the public service bill by 7.5% on monies that we don't have. So I don't know where this money is going to come from. But so I think that would be a difficult one. And if it is imposed, it will certainly be challenged on various constitutional grounds. So you go,
Fiona.
So we know that we've got some support for cabinet ministers being able to introduce the directives and if you like, instructions with regard to how to deal with this state of disaster. And that was the Fair Trade Independent Tobacco Association case against the President of South Africa. And of course, there, what the court was looking at is a situation where the current legislation could never have contemplated the particular disaster that is being experienced. And that leads to directives needing to be put in place to, if you like, go back to my earlier point, fill the gap. Now, we don't know quite how far our Minister of Employment and Labour may go. I don't think he can ever prohibit retrenchments, because that is just not going to be palatable in terms of an employer needing to stay in business. But what could happen is there's a greater emphasis placed on the alternatives to try and avoid the loss of employment. And that would fit with what the Section 27 says in the in the legislation that pins this, the Disaster Management Act, because the protection of livelihoods is an issue, and that's in the declaration itself when the emergency was declared. So if I'm protecting livelihoods, it's jobs and the lives of dependents that are reliant upon the breadwinner earning. And so you want to keep perhaps the benefits in place, even if earning capacity is down, but you want people to remain in employment rather than that they are out of jobs completely. And I think that would be the thrust for any directives or instructions issued by the minister.
Fiona,
yes, please go.
Sorry, no, I was just thinking, I made a note earlier that, and it touches on what Fiona said. I think that in any plan or whatever you want to do is try and find incentives so that employees would, for instance, if there's a no pay scenario, that they keep their benefits in place or some sort of alternative. But again, getting back to the principle of being very creative is important.
And I think any sort of proactive framework agreement will piggyback on, following on Tony's subject to the regulations, or if this agreement directly conflicts with any direct prohibition on legislation. If one had to had a crystal ball before COVID, one would have adopted a mandatory vaccination policy, and people would have just said, yes, we wouldn't, right? We're now sitting at various things. So the fundamental difference between COVID and now is we have time. At an individual labor law perspective, I think what has come out is be mindful of people's experiences during the short bouts of level 6 and level 4 load shedding when meting out discipline. But unlike COVID, where you didn't have time, you have time now. And if you're not sitting at the C-suite, giving your input as employment lawyers, your organization is missing a great opportunity to start the process. As Brazil, as the articles and the research and the case studies on Brazil and Argentina says, this is inevitable. The warning signs are there. The building blocks have been put in place for long bouts of load shedding during the winter months. Our water situation is going to get worse because of load shedding. And this, I'm not being fatalistic, but if we had to be purely practical, we need the building blocks. Fiona, concluding remarks.
I think this has been a fascinating discussion because we are right in the center of something we haven't experienced before to this magnitude, and particularly if water is also going to become an issue alongside the issues with our grid. And so we can't sit on our hands. We have to be proactive. And I think the sooner one can get into that dialogue with one's workers, the better.
Thank you. Hugo, concluding remarks.
Yes, proactive, be brave, revisit all known principles, revisit the principle of a tacit agreement. In all of those, there's a scope for an alternative argument, and we must explore that. But be brave and be proactive.
Colleagues and friends, I trust you enjoyed our speed dating seminar. And as we undertook during COVID, we promised to keep you updated and be at the cutting edge of this. And Nadeem, our professional services lawyer, will be releasing a thought leadership piece like we did under COVID. Keep a watch out for that, where it will have questions and answers. And just simply to guide your thinking. We don't have the answers. Like COVID, this year is a moving target. Look out for the document, but most importantly, start the engagement. And once you start the engagement, and this is free marketing for us, so please give us a shout and we can travel this journey with you. Thank you all, and to our market and our business development team, Karushka, Heidi, and Andrea, and thank you all for joining. And a recording of this will be sent to you if you've registered, so you can keep it there. Thank you.
Thank you.
Cheers. Thanks. Bye.
Bye.
Thank you.